Hello, everyone. My name is Felix Shipkevich. I'm a partner at Shipkevich Law Firm located in New York City. And today we're going to be doing a webinar on Forex regulation, specifically covering U.S., U.K., Dubai, and Japan. Before I go into the presentation, if I could just ask for all questions to be left at the very end, and I'll be more than happy to answer each one of you. The additional item is if there are any subject matter that it would be of interest to you for any future legal and regulatory subject matter, please email me. I'll provide my contact information at the end of this presentation, and we'll be delighted from all the members and associates of the Shipkevich Law Firm to offer future webinars and seminars on subject matter of interest to the readers. So let's begin. A little bit about ourselves. I spent 5 years working as a general counsel for a large retail foreign exchange broker called CMS Forex. Since CMS Forex, I have been a principal at the Shipkevich Law Firm located in New York City, specializing in foreign exchange, futures, and commodities transactions. We're a boutique firm, and foreign exchange is what we do. So let's talk about FX regulation. Essentially, there are three timelines that I'd like to introduce you to. The first timeline of FX regulation is between 1995 and 2004. Why 1995 to 2004? As most of you know, there haven't been that many retail brokers, if any, prior to 1995, until the internet became mainstream. And from 1995 until 2004, you essentially had a number of brokers that became registered with the authorities in the U.S., U.K., Japan, and Dubai. During 1995 to 2004, these jurisdictions did not have that many FX regulations, and for jurisdictions like UK, Japan, and Dubai, while the local regulators began to oversee these industries, we did not see the first set of regulations covering FX until 2004. And we'll discuss that later. In 2004 until 2008, you have a first wave of regulations covering trading, electronic trading systems, promotional materials, and overall the subject matter of FX. And 2008 until present, you have a second wave of regulatory oversight coming not only in the U.S. with the emergence of the Farm Bill of 2008, which we'll discuss later in the presentation, but also with a set of regulations coming out in Dubai, Japan, and UK. So who are the regulators? In the U.S., the regulator that's part of the U.S. government is the Commodities Futures and Trading Commission, the CFTC. However, the traders and the participants in the market space are all familiar with the National Futures Association, or the NFA. The NFA is the DSRO, also known as a designated self-regulatory organization that has the powers and authority to regulate the FX industry, as well as the futures and commodities industry, on behalf of the CFTC. In the UK, you have the UK FSA, which is a single regulator overseeing not only the FX, the futures and commodities industry, but also banking, equities, and insurance. In Dubai, the DFSA, Dubai Financial Services Authority, oversees the financial markets as a single regulator. And in Japan, as you see, you also have the Japanese Financial Services Agency. However, you have two additional regulators. One is the FFAJ. FFAJ is similar to the designated self-regulatory organization as the NFA in the U.S. However, the FFAJ serves more as liaison to the industry rather than the regulator. It's a membership organization. It holds meetings regularly. It seeks the industries, the FX industries, and the futures industries, comments and suggestions on how to better improve and regulate the industry, but it does not conduct audits. Instead, the audits and the oversight of the industry is conducted by KLFB, known as the Kanto Local Finance Bureau. So if you're a broker-dealer in Japan, you're not going to get a visit from the JFSA, you're going to get a visit from the KLFB, which conducts regular audits. How the regulations differ between these four jurisdictions. And here's why I separated these into two types of categories. U.S., and then you have UK, Japan, and Dubai. U.S. in the past 7 years, since 2004, has promulgated very FX-specific rules. They are specifically geared towards FX brokers, introducing brokers participating in the FX market space, CTAs participating in the FX market space, and pools participating in the market space. In UK, Japan, and Dubai, the rules are not specific to the industry. They're specific to the entire sector that is overseen by each regulators. And we'll go into examples later on. So let's start off with the United States. The Commodities Exchange Act, also known as the CEA, define what is a futures contract. And in 2000, the Commodities Futures and Modernization Act, also known as DCFMA, define a spot forex contract to be a futures contract. Now, between 2000 and 2008, you essentially have what's called a Zona loophole, where two federal circuit appellate courts held that spot forex contracts were not deemed to be futures contracts. As a result of what's known as the Zona loophole, in 2008, Congress passed a farm bill providing the CFTC with the authority to oversee the retail FX market. Second, it clearly defined the spot FX contract to be deemed a futures contract in order to overcome the Zona loophole. And it asked for the CFTC to draft rules that are specific to the FX industry. And as most of you know, in January of 2010, the CFTC proposed close to, if I'm not mistaken, about 90 pages of FX-specific rules, and it provided the public 60 days to comment. Now, interestingly, and I'm confident that some people participating in this webinar probably submitted their own comments to the CFTC. The CFTC received over 10,000 comments, arguably probably more comments than for any other rule proposal they ever had. Most of the comments were suggested by those commenting to fight against the cap on leverage to be 10 to 1, and obviously they succeeded, and the leverage was then capped at 50 to 1 and 20 to 1 for minus, but we'll discuss that later. The rules went into effect on October 18th of 2010. Three things that I want you to take away for what these rules really meant. The first thing, it set out registration categories. Any broker-dealer participating in the retail foreign exchange transaction as a counterparty had to be registered as an RFED, or retail foreign exchange dealer. It also sought registration for introducing brokers, CTAs, and CPOs. Second, the CFTC wanted to make sure that the public is aware of the risks involved in participating in the retail FX market, and as a result, you had a number of disclosure requirements for RFEDs on a quarterly basis, and for CTAs and CPOs at the time someone is participating in their programs, to disclose the risk of the speculative nature of retail FX. And finally, the capital requirements were set out at $20 million plus. It's not really $20 million, it's actually $20 million plus you have 5% of all liability, about $10 million, but that's a little bit complicated. So think about $20 million plus for RFEDs. So these three items were the most important items of the FX rules that went into effect just about 6 months ago. Well, we partly covered the registration aspect in the previous slide. The other important aspect of these rules is that it provided the CFTC with the authority to revoke or deny any registration for a member who did not qualify to be registered as a Forex firm. And finally, as you probably have read in our blogs on FX Street, as well as in our own blog, there have been a number of enforcement cases filed against Forex brokers in the past 2 months. There were, in fact, 15 filed in the past 2 months, and at the very end of the presentation, you'll see who the defendants were. Let's talk about the United Kingdom. As most of you know, London claims to be the home of the retail FX. I mean, I will have to agree, as today, other than Tokyo, London houses more FX brokerages, retail FX brokerages, than any other jurisdiction. I see there is a question. If I could just ask the questions to be left till the end so we can get through this. So what regulatory environment exists in the UK? Well, since 2004, the FSA, and if you remember at the beginning of the presentation, we talked about the second period, right? The first was 95 to 2004, then it was 2004 to 2008. So in 2004, the FSA began to draft industry-wide, and not only FX, but futures and commodities, regulations to further oversee the financial capability of the markets, right? And the purpose of that was to raise confidence among consumers to make sure that they're comfortable in participating in the products. Obviously, with the internet coming to mainstream in the mid-90s, the FSA became extremely concerned that some of the new products that came out as a result of the mainstream internet platforms, they wanted to make sure that this was all being covered and regulated. So what type of regulations exist? Well, first of all, UK FSA does have pretty strict financial standards. There are several categories for registration for FX brokers. The highest permission level is known as the 730K firm, 700,030 euro firm. So that permission allows you to participate in FX, CFDs, and spread betting. Next level is a 125K firm. 125K firm allows you to also accept client funds, but you cannot take any risk. It must STP or offset all of the risk with qualified counterparts. Brokers must submit financial reports for FSA guidelines, and if they're fined or penalized by the FSA, then this is all publicly disclosed. And FSA does keep a pretty formal record of all proceedings, similar to the NFA CFTC database of proceedings against member firms in the U.S. If you log into the FSA website and you type in the firm's name in its registration section, you can actually see who has been penalized and what actions have been taken. So the one unique feature, and I'm sure that you guys have, I know about, pretty familiar with this, is that UK law, UK FSA laws require for the FX funds to be segregated. What that really means is that in the event of any insolvency or bankruptcy, the funds, the clients and their funds become secured creditors. In the U.S., you don't have the same protections, unfortunately, and during our last webinar, we had a lot of questions about why that was the case. But in the UK, that protection is offered to retail FX participants. Last year, the FSA announced it intends to, as you probably heard, abolish itself or dissolve itself, and that the responsibilities that they say would be transitioned to the Bank of England. The transition was expected to take place in 2012. That is yet to be concrete. It's still debated whether the Bank of England should be regulated the entire financial sector. So I wouldn't say for sure that that's going to happen by next year. What's interesting is that a few weeks ago, if you go to the FSA website, the FSA published its first retail conduct risk outlook paper. It's a white paper that highlights consumer protection challenges facing the FSA, as well as possibly the Bank of England, who may or may not regulate the industry. What this white paper seeks to do is it seeks to raise awareness of risks, form the basis of dialogue with consumers and firms to help in preventing these risks. Furthermore, it identified three key categories which should be of concern to consumers. The first is how does your FX broker, how does your member firm, how does your futures, commodities, equities, or an insurance broker handle your customer complaints? And we represent a number of clients in the UK, and we've definitely seen a lot more due diligence by the FSA to see how the complaints process is being handled by the respective member firm. Are they responding to the customer complaints timely? How are they responding? How are they documenting it internally? Next, the emerging risks such as investment risk profiling and the popularity of complex investment products. What that really means is the FSA's concerned that with new technology, there are more new financial products, more products that are over the counter, and are risky to consumers. So the second point is the FSA wants to know how to make sure that the customers understand the complexities of some of these products, as well as the risks associated with these products. And finally, there's concerns regarding the tax challenges and the application of the products. Certain speculative products, like spread betting, for instance, to the best of my knowledge, are not taxed for UK residents. There's no capital tax basis applied to the gains. So that's another item that the FSA is looking for. So the result of this white paper is that there are obviously a lot of issues the FSA wants to start reviewing. And the focus is it wants to build road testing for a new structure in order to divide its operation into and conduct its prudential matters in a more efficient way. The FSA is a very enormous organization. And you think about a single regulator in the UK overseeing all these different products. And what the FSA wants to emphasize in the white paper is that it wants to make sure that each one of these products is properly audited, supervised by the FSA. Let's talk about Dubai. We've definitely seen a rise in number of FX brokers setting up shops in Dubai. And as a result, I think it's interesting to cover it. Once again, we were talking about 2004. In 2004, the Dubai Financial Services Authority, the FSA, was established. So it's interesting how in UK and Dubai, 2004 is a key year. The Dubai FSA it reports directly to the President of Dubai International Finance, which is most of you know known as the Financial Free Zone. The DFSA, similar to the UK FSA, oversees a wide range of products, from banking, securities, various investment vehicles and funds, trust services, commodity futures trading, Islamic finance, insurance, and equity. There are about 104 firms registered right now with the DFSA, and interestingly, 40%, which is a pretty big number, of these are banks, branches of banks regulated outside of Dubai. In January, just a few months ago, the DFSA published its business plan for 2011-2012. Also, freely available for view on the DFSA website. What this white paper, this business plan, discusses is it wants to make sure that Dubai as a jurisdiction continues to maintain a high quality in all regulatory and support functions. It has a large international engagement and collaboration with other authorities. In fact, about 6 months ago, DFSA and the CFTC signed a memo of understanding in agreeing to cooperate in certain type of matters, such as investigation, by sharing information with each other. And obviously, similar to the UK FSA, the DFSA seeks to enhance the existing monitoring and analysis of firms to detect possible stresses with regulated activities. What else does this business plan set out? It sets out capital requirements. The DFSA is looking at possibly increasing capital requirements for member firms in 2011, 2012. It's looking to concentrate more on the compliance responsibilities and internal controls. And as I mentioned a few minutes ago, it intends to have further cross-border and international cooperation with other jurisdictions. So there was a report filed last year that set out its progress made over the last years, and now it's looking at 2011 and 12. So what are some of the achievements in Dubai? I mean, as I said a few minutes ago, Dubai became a pretty well known jurisdiction for FX brokers to set up offices. First, in 2010, Dubai set up a new fund regime scheme to allow more flexibility for commodity pool operators and hedge fund managers to manage funds that are located both in Dubai or outside of Dubai. The DFSA representative office regime came into force, and 7 representative offices have already been authorized, which shows expansion of the DFSA. And they took a pretty interesting enforcement matter against one of the members, which is actually the first one of its kind. The matter was called Demas International Ltd, and this was a matter against the board and majority of shareholders for breach of corporate governance, failing to oversee the management of the company. So Dubai was not known to be a very, in the past, strict regulator to go after the member firms, but it looks like it's following the footsteps of the CFTC and the UKFSA by going after the member firms. So in addition to some of the compliance changes, DFSA in this report stated that it'll conduct a number of reviews, going to start monitoring and auditing of the member firms, and some of these reviews will cover the following items. So one, consumer protection and suitability. They want to make sure that clients understand the speculative nature of the products, if they're participating in these products, market conduct by firms engaged in trading activities, business contingency planning. Obviously, today, in light of the tragedy in Japan, business contingency planning, very, very important for financial institutions, and corporate governance, how the shareholders and the board oversee the day-to-day operation of the firm. And obviously, following the financial crisis, which affected Dubai significantly, the DFSA noted that it'll be focusing on record keeping and accounting supervisions. Now we get to Japan. I go to Japan quite often on business, and I find it amazing that, regardless of the number of regulatory changes that took place in Japan in the past few years, the number of rules that affected the industry, the FX brokerage industry is very strong, with over 100 participants in the market space, 100 broker-dealers involved for FX, retail FX services. And here's why. Here's interesting. Japan, Japan is one of the few jurisdictions which is so transparent that it actually posts the audit reports of its member firms online. You can actually go to the Regulators website and see what type of deficiencies were noted in the last report, the last audit made by the Counter Local Finance Bureau that I mentioned earlier, the auditing arm of the FSA. Right? On top of that, which is kind of peculiar, in Japan, you can actually see when a broker is being audited and how long the audit took place. You don't see that with any other regulators, at least not in the U.S. and UK or Japan. Okay? So what's been going on in Japan? Well, as most of you know, as of August 1st of 2010, the leverage for margin transaction has been reduced to 50-1, and that leverage is going to go down to 25-1 as of this August 1st. A few months ago, the GFSA announced that it's going to attempt in revising and amending the Financial Instruments and Exchange Law, which governs the FX market, to counter fraudulent activities in the market space. the FSA plans to use a panel of experts and financial industry representatives to implement up-to-date policies for the industry. Similarly, a few months ago, the JFSA announced that it will propose to amend the FIE, Financial Instrument Exchange Law, to counter increased fraud by unregistered securities agents, and means that it's going to be difficult for some of the bet operators to conduct fraudulent activities. The FSA wants to make sure that it's going to be easier for the government to refund the funds back to the victims, as well as raise penalties against unregistered agents of sale of financial instruments. So that covers up, that finishes Japan and gets us to the end of our presentation. So what are the effects of regulatory changes that took place in the last few years, from 2000 to present? First of all, we've definitely seen the eradication of fraudulent activities in the industry. We've seen regulators like the DFSA going after member firms have been wrongdoing and taking enforcement steps. You've definitely seen the UK FSA step up its efforts in going after member firms for failure to supervise AML, promotion material, failure to properly treat clients' funds correctly for FSA rules. And obviously you have the CFTC, and I listed, as I promised you, on the right-hand side, you have 15 CFTC enforcement cases that were filed since the beginning of this year. There will be a lot more, and see what's going to shape up in the U.S. My contact information and Juan Miguel as our associate is listed below. Please drop us an email or call us. Our blog is cftclaw.com. We regularly post new developments throughout these jurisdictions, and now I'll take some of the questions. So I'll go back to some of the first questions. The first one was Paul Walker. Paul asked, he's troubled by the extraterritorial jurisdiction of the CFTC has claimed himself. Do you agree that they've gone too far? Well, Paul, it's a good question. Obviously, the CFTC, as you probably have seen on Forex Crunch and other forums, there's been an email circulated from one official at the CFTC that foreign firms soliciting U.S. clients without registration will face an enforcement action. So here's where we are today, right? And you said that suing FX brokers and having all this addressed. I don't think they've gone too far. I think at this point they're actually following the letter of the law. The firms that they've gone under, those 15 firms, even though most of them are foreign, they did have some level of operation in the U.S. If you take a look at the complaints, and the complaints are publicly available on file, the complaints set out how the Commodities Exchange Act was violated, right? So, they're not going after the, London-based firms with U.S. clients, but they will go after London-based firms who specifically target U.S. clients. Okay? Let me try to get to other questions. What exactly does the financial free zone mean? Financial free zone means several things. So in Dubai, the financial free zone means that there are very low tax implications. And contrary to some of the other jurisdictions in the Middle East, Dubai allows for more financial products to be traded and offered in the Middle East versus Saudi Arabia. Then we have Mark, sounds like the UK is a good place to incorporate an agency broker, or is it a better jurisdiction to reassure clients but not raise compliance costs? How expensive would registering be? Mark, all of this is going to depend on there are two types of agency brokers in the UK. It depends on the business model. The low end capital requirement is 5,000, and the higher end is 50,000. euro. It's actually euro, not sterling. I can't comment on which jurisdiction would be better. It depends on whether you do not do business in the U.S. If you do business in the U.S., you have to register with brokers. In terms of the cost of registering, feel free to give me a call or drop me an email, and we register. Our firm registers IBs, we register RFEDs, FCMs, IBs, CTAs, and CPOs in the U.S. and UK, so we can provide you with more information. You give us a call. Then there's a question: are you aware of the problem with FXCM? I'm not really sure what problem. So if you want to maybe comment on that. Let's see. I'll call you. I'm getting to there was one of those forms representing this probably for the purpose let me. I haven't opened up the link, but call. Give me a call if you have more questions. Drop me an email. I haven't. So out of the 15 complaints, you go to our blog, cfpclaw.com. We actually provide an update. Nobody has challenged the CFPC's jurisdiction yet. You have to have valid ground to challenge the federal government. In fact, most of the firms have not even responded to that, to my knowledge. So if they hadn't responded, they would be placed in default, and we create a lot more challenges for them. Just come visit our blog and up on RSS feed and provide that. Next is, what is your opinion of U.S. wanting to control their citizens trading outside of the U.S.? I don't think the U.S. government wants to control citizens trading outside the U.S. I think the U.S. government today, opening from bank accounts to trading equities, commodities, futures, and effects, or other products outside of the U.S. I do travel quite frequently, and I ask that question for non-U.S. broker dealers if they accept clients. And they do. As long as those firms don't specifically solicit your clients and the clients act for them, I don't think the U.S. government is doing it. Paul, they're not appearing or replying. Well, checked a few days ago. Out of the Jade Effect has been sort of resolved. There's a consent order in place from the website, but 14. I think other than one, no one has replied to the complaint. I don't want to mislead anybody, but a few days ago, when I say appearing means that no counsel has appeared on behalf of these defendants. And the next thing I have is business trial with Morgan. All right, so you're talking about a class action against FXCM. I can't comment on this action. I read the complaint, but at this point, I don't comfortable commenting on this action. I think it's interesting that you had a couple of RFEDs being sued by one particular law firm in Florida, which is Morgan. I don't know well enough into the fact that you put complaints whether or not that is true. I think we'll have to wait to see and continue to cover this matter, see whether it's not. So Harry just asked me if I agree with the CFPC rule. This is going to be my opinion. Personally, I agree with some of the rules and I don't agree with others. I think I agree with registration requirements. I think it is important for the CFPC to require registration of CPOs, CPAs, and IBs. I think it was important to set for capital requirements. Disclosure was an important part of it. I did not personally, and I don't think personally agree with the leverage. I think it makes U.S. very anti-competitive and essentially as a lot of the brokers flow the business of borders and don't show up or just stop their business altogether. The FX industry created, thousands of jobs in the country. Shame that the price is discouraging business here, especially. Mark, to your question, yes, we work with different jurisdictions. We are lawyers located in New York City. However, we do work with clients throughout the world. In fact, I think multiple clients. And then the question is, do you think brokers want to sell stock where traders I don't think they do. I actually, I think we didn't anything interesting about that. And I'm going to give it another few minutes. If anybody has any questions next 3 minutes, otherwise, I hope to see you. I'll have to see you guys again. I feature webinars, FX regulations, traders, and details. Thank you, everybody, and look forward to seeing you at future webinars.